Hi, Assalamualaikum warahmatullahi wabarakatuh to my handsome lecturers, Sir Firdaus, and my beloved friends. Okay, before I start my presentation, I'm gonna introduce you myself and my fellow members. My name is Muhammad Abdul Shakur bin Johadi, and we have Muhammad Sakan bin Zulkafli, and also Muhammad Khairil Haziq bin Khairuddin, and the last one is Fitri Sulaiman bin Sisir. Now we're going to talk about the elements of the licensing program. Let's start learning. So, the objective of this learning is to identify the characteristic of licensing agreement and differentiate of trademark and patent. What is licensing agreement? License will exist if there is a contract between two or more parties with explanation what property of rights that licensor agreeing to give up to licensee. That means contract will happen if licensee and licensor make a contract. There are some licensing agreement which is lengthy and complex document. Generally, documents that contains the same provision, such as advances, royalties, guarantees, market dates, renewal options, length of contract, monitoring right, inventory and return, procedure of quality control and allowance. So, what is characteristic of licensing agreement? Number 1. Identify the parties to the agreements. For example, you sell a product. You want to use someone's name to use your product. Then you need to know who are there. You need to know their background, their purpose, and they need to know your company. Number 2. Identify the duration of the agreements. For example, company A make a contract with company B. In the contract, they state the contract only remain for 3 years only. After 3 years, the contract will terminated. So, that is the duration of the agreements. Number 3. Specifies the subject matter to be licensed. That means the purpose of the contract. For example, you want to make a contract with soccer player like Cristiano Ronaldo. So, in the contract, must be full of the detail what they need to do, what their rights. So, both of the parties agree with the terms. So, that is specifies the subject matter to be licensed. Who may use the IP? What is IP? IP is intellectual property. The license may be a company or a group of companies, another type of corporate body, or individual or collection individuals. Some license can be cover entire enterprise and bind not only for the company but to the users of the products. For example, you have owned the product, so you can use the IP. Duration of the licensing. The term of duration of the contract. It can contain by fixed period, any initial minimum period. They can right renew or automatic renew after the contract terminate, or the both parties have right to terminate by notice, and the last one, length of the notice period. What IP are you licensing? This could be a patent which is protected by copyright or a trademark. Next is you may be licensing more than one sort of IP. The last one is you may license IP from someone else. In turn, you want to license that IP to another business. Number 4. Characteristic of licensing agreements is limitation of license. Be specific about what license may do with the IP. There are 3 main types of license. The first one is exclusive license. No person or company other than name of the licensee can exploit the IP right. Even though you are licensor, you cannot exploit the IP right. The second one is sole license. Only one person legal can exploit the IP right, which is licensee. The third one is non-exclusive license. The licensee can exploit the IP right and the licensor remains free to exploit the IP right. Number 5 characteristic of licensing agreements is exploitations. The point is charge and payment. Consider how the license is going to earn a return. For example, company A make a contract with company B to gain a profit. Next is consider what and how you have to pay. For the example, company A need to pay to the company B 70% every month of their sales. The last one is think about what criteria you will use to value the IP specified in a license. Number 6, the last one of characteristic licensing agreements is settlement of dispute. The point is governing law and dispute. If entering a license with a party in legal jurisdiction, you need to know which country laws that should apply. There are 2 aspects involved in dispute resolution. The first one is the law that should govern the agreement. That means the contract is attached by the which country law. The second one is the appropriate method to resolve is the party decide to resolve by parties or the judge.
Assalamualaikum warahmatullahi wabarakatuh. My name is Fitri Sulaiman bin Sise and I will continue our slide about the trademark and patent. So as we know, trademark can be a symbol, logo, word or color that is legally registered or establishing use as representing a company or product. If you one day want to have your own company, you must make sure do not take any design from internet or Google to be the logo of your company. This actually happened to me when I want to have a logo that acronym with my name, which is Fitri Sulaiman. I searched on the Google and I found that the logo that I want and I use it for my marketing. One day, one of the staff that I use of their logo personal message me to ask about the logo. Luckily, he not sue and advised me to change the logo. This taught me to be careful about the logo of my company. So, licensor must exercise some degree of control over the nature and quality of the licensed trademark goods or service. These are the example of Adidas logo has shown on the both Bayern Munich jersey because they sponsored that team. If you want to know, the red jersey is designed by Human Race, which is company that handled by Pharrell Williams. Next is about the benefit of trademark. So the first one, enable consumer to identify a product of a particular company so as to distinguish it from other identical or similar product. So the number 2 is protecting the brand by trademark registration. It means that the licensor has secured the company from any abuse of their logo, word or number. The third one is provide an incentive to company to invest in maintaining or improving the quality of their product in order to ensure that product bearing the trademark have a positive reputation. Next is international expansion through international sale. If your business goes to international level marketplace, your brand or trademark will be known by others country. This will help your sales on that year increase. The last one is licensing for profit. After we registered the company, then we legally can sell our product or service and expand to the international level. So the next is about the characteristic of a trademark licensing agreement. There are a few of characteristic of a trademark. So the first one is identify the parties to the agreement. Means that we need to identify either the company, state place, registered number or not. If they not state all of each, so how the agreement can be proceed? So the second one is identify of duration of the agreement. They need to know the due date or how long the time frame. The third is specify the product or service. We need to know what is the company sell either product or service. The fourth one is the license exclusive, non-exclusive or sold. And next is exploitation, and the last one is the settlement of dispute. Okay. Next is about exploitation. In exploitation, we have responsibilities of the license. This means quality of product and usage of mark, and to supply promotional literature and a sample for licensor approval. It also to supply account to the licensor. It also have the responsibility of the licensor, which is to provide the requisite know-how and assistance, and also to maintain of registration of the mark. And in exploitation, we have ownership of trademark. This means acceptance of the licensor ownership of the trademark and goodwill by the distant, and agreement not to be challenged. Next, we are going to the topic which is settlement, and we have the infringement, control of proceeding, cooperation in proceeding, cost of proceeding, and right in respect of damage or settlement. So we have done about the trademark, and now we will go to about the patent. So how you know about the patent and what you know about the patent? A patent, a form of protection that provide a person or legal entity with exclusive right for making, using or selling a concept or invention, and exclude others from doing the same for the duration of the patent. If you have secured a patent, no one can have authority to do same as you do. Only an inventor may apply for a patent on his or her idea. If two or more people participate in creation of an invention, the law requires that all participants apply for a patent as joint investor. As example, if me do a patent or idea, and then Zakwan and Khairil want to participate me for creation of invention, they will call as a joint invention. But if Abu want to join, but he just give some financial contribution, which is money, he can't be named as a joint investor. there are two types of entrepreneur-related patent, which is design patent and utility patent. So the essential distinction between design and utility patent is the difference in protecting how it's look for design patent versus how it's work for utility patent. If you are concerned about competitors copying the appearance of your concept, then apply for design patent. If you want to protect the functional features of your concept, then apply for utility patents. In some cases, it may be appropriate to file design and utility patent application. Utility patent is more expensive and require more input than design patent, and it also have a long term, which is 20 years, compared to design patent, which have 14 years. For this example, Nike was granted more than 540 patents by the US Patent and Trademark Office in 2013, but only 60% from 340 in 2012 are made by Nike. Many of Nike latest patents integrate digital technology into sport equipment, so user can measure and improve result. As example, the company introduced the full band bracelet, ideal for recording calories burned in an exercise, and also Nike make a deal of a golf shirt that replicate what a coach does. The clothing has the tired materials in areas key to a repetitive movement like a golf swing.
Assalamualaikum. My name is Muhammad Zakwan bin Muhammad Zulkafli. Today, I will introduce to you about product licensing application. Product licensing application is a step for us to get a license for our product. So in this slide, we will study about case that have been given. So for the example, case 1, it is about you have a new product idea that you believe would sell very well were it only available on market, but you do not have the time or resources to manufacture it and sell it yourself. So for the case 1, how we want to solve the problems? The first thing is we need to try to license the product idea by finding an existing product line manufacturer that already selling other product into your target market. Try to convince them that they should add your product to their product line and share their profits on that product with you, which is we can gain a royalty on their sales of that product. So when you get the license, you can gain profit by get a royalty from the manufacturer that you collab with. So next, in case 2, an example which is brand managers wanted to enter or extend their brands into new product categories to drive strategic growth for the company. So next, to settle the problem from the cases 2, we will look on the diagram had been shown on the slide, which is there are different stages that are part of the licensed product process flow. So for the first stage, I will explain to you detail one by one. We will go through one by one to make sure that you understand the stage on this process flow. So for the first stages, licensor picks the product categories to be licensed, which is licensor. As an example, Nike will choose one of their product to be categorized and be licensed, And then the second stage, licensor or its agent finds and negotiate a license with the best licensee. So, as an example again, Nike or Nike agent will find and negotiate to get a license with the best licensee. After Nike get a best licensee, the licensee will develop a concept, prototypes, and final production samples and submit it for approval. So in these stages, it's shown that the licensee that have been chosen by Nike or Nike agent will prepare a developed concept, a prototype, or final production sample to Nike, and Nike will evaluate, look on the product, see how compatible the product, how good is this product, could it be sold, and then after Nike approve it, the product can be sold in the market. So for the last stage in this process flow, licensee sell the licensed product that have been approved by the Nike in authorized channel to retailer. Okay, we go through into the next slide, which is, in this slide, I will explain to you about the factors affecting application of new product licensing. There are 7 factors that can affect your application of new product licensing. So, for the first one, idea is probably not new, which is the possibility that idea have been created by ourselves, have been tried already by the others, or it has been already patented by someone else before. So, to overcome the idea is probably not new, we need to do a professional patent search with a fee, such as we can get an example logo, a logo on website that we need to buy it from the website. So next, second factors, it may not be possible to manufacture your product at the cost necessary for it to retail at a price customers will pay. Next, the product's potential sales are not large enough to be of interest. If you use the same idea and you create a same product that have been sold by the others, your potential sales will small and you cannot gain more than the original one. So, for the next slide, we will continue factors that affecting application of new product licensing. For number 4, the required front-end investment is just too large or too uncertain. Want to know what is front-end investment? Okay. Front-end investment is an outlay of money at the beginning of the expected life cycle of a product or event. So, for the next point, it is the required operational change are too great, which is there are many changes in operational, so that it can be a factors, one of the factors that affecting the application. Next point is you approach them incorrectly. So the way, it is maybe the way you approach people, the consumer, about your product, not in a good way, I think. So you must approach them, the consumer, with politely and introduce to them about your product and what is benefits of your product. Lastly, the company going through hard times or a management change or just have too many new products on their plate right now. So another factors that can affect the application is maybe the company is going a hard time, maybe they have a big problem with others in the management, so or maybe they have many new products that weighted in listing that need to be approved to sold on the market.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Khairi Hazim bin Khairuddin. Today I'm going to continue the presentation that have been made earlier by my friends about the licensing agreement. And today I'm going to present to you about the topic of legal and practical issue in licensing agreement. In licensing agreement, we shall learn about the exclusive license, which also can be defined as the exclusive license that has been authorized by the licensor to the licensee to exploit the mark in the territory to the exclusion of all others, including the licensor, and therefore the licensee is protected from competitions. It is common in practice for exclusive license. And then next we go to sole license. A sole licensee is granted a more limited protection from competition, where the licensor himself reserve the right to compete with his licensee in the territory, but he promises not to appoint any other licensees. And as for non-exclusive license, it is not offered any protection from competition or whatsoever, and the licensor remains free to appoint other licensee in the territory. For non-exclusive license, it is different from exclusive and also sole license. It is because non-exclusive license, they did not offer any kind of protection from any competitions in that territory. Next is about territory. It is possible to grant a global license in a respect of a trademark, but however, it is much common to grant license country by country. That is the best way to clarify and to give license to the licensee to produce or to take out all of the product that has been produced by the intellectual property given by the licensor. Next is to cover the activity by the license. A license may be granted in respect of the full range of the commercial activity that will be done by the intellectual property of productions, which is the manufacture process, the promotion activities, the distribution activities, and the retails for the intellectual property. And it is alternatively possible to grant one party a license to manufacture the product, another to distribute it, and another one to sell it to the consumer. That is one of the best way to give the license for producing out the intellectual property production and to produce a product by the intellectual property. We should give the license to the one that are manufacturing it, and another one to the one that distributing the product, and last but not least is to give that license to the seller, to one particular person that sells it to the consumer, and that will make the consumer know about the product. And next, we go through the royalties. The royalty clause often involve extend negotiations. The greater the degree of exclusivity, the greater the royalty rate. And the licensor frequently attempt to impose minimum royalty rates on the license to guarantee a minimum returns for the licensor. The royalty clause is carefully drafted so that it work well in practice. The royalty also give us the information about how big the royalty that will be received by the licensor upon the intellectual property that has been given license to produce, to manufacture and to sell it. So it is clearly defined that the greater the degree of exclusivity of the product, which also give the means that the higher the exclusiveness of the product, and the greater, the bigger the royalty that will be received by the licensor. We go through the usage and the quality control. It is important for a licensor to produce a license that contain suitable provisions on the usage and the quality control of the intellectual property. And this is very important because to prevent the licensee from using the trademark in any manners which could mislead the public with regard to the origin of the good or lead to the mark becoming so generic. It is advisable to include right to inspect sample of the goods that has been produced by the intellectual property at the licensee expenses, and the licensor have to reserve the right to terminate the license in cases of material breach. Next is assignment and sub-licensing. In this point, it explains that license should specify what rights the party have to assign or sub-license their interests. It is common for licensor to specify that no assignment or sub-licensing to be permitted by the licensee. An appointment is only in respect of whom the licensor has indicated his written approval. Next is for the advertising and marketing. The licensor may want to impose advertising and marketing obligations on the licensee in order to maximize the likely return on the license they give. The licensor also should reserve the rights of approval over advertising and marketing materials produced by or on behalf of the licensee over the product they want to be marketed in. And the right on third-party infringement. It is common for the licensor to refuse to grant his licensee any right in respect of third-party infringement, including the statutory right which will otherwise apply. This is because there is a risk for the licensor in giving up control of the infringement proceedings. For the next point, we shall go through the competitions law. It will be important during a negotiation for a trademark license to consider the competitions law in the marketplace. But somehow, competitions law occur to be in the marketplace because it is upon to control the monopolistic unfairness and the restrictive trade practice by creating a set of policies that enhance the competitions or the competitive outcomes in the markets. The next point is the registration. Registration is not a mandatory things to do, but it is advisable to be registered in a body of a governed body. A licensee will be prevented from obtaining damages or an account of profit relating to any period when the license was unregistered. And next, for transactions and for the behalf of the licensor, the royalty received will be treated as trading receipt for corporations or income tax purposes. And on the behalf of licensee, it is clear that the royalty paid for the use of the trademark will usually be treated as trading expenses, and it will be deducted in the calculations of its profit of the licensee organizations. Last point, we go through the confidentiality. It is depending on the type of goods or even services concerned. It is advisable for the licensor to insist upon a confidentiality agreement before negotiations for the license begin, especially with related know-how or other intellectual property right under the terms of the license. We shall continue our part with the case study about a trademark infringement disputes. This case study is a study of the trademark infringement dispute that has been linked to the author, that is M. Cosgrove, that is incorporated to the Econolas Incorporated in 1979. The company provide market publications to financial and non-financial institutions and owns the trademark Econolas. And over the past year by year, others has attempted to use the same name for similar kind of services that the Econolas giving out to the others. The cases study present the practical step that Cosgrove undertook to prevent infringement in his trademark in various cases that occur since our prior paper was published in 2005. That is Cosgrove, Marsh and Chester. The paper also explained the basics of trademark law, the meaning of trademark infringement, and the obligations of the trademark owner. This case explains about the benefit of protecting the brand by trademark registrations. This is the actions that has been taken by M. Cosgrove towards the Econolas trademark that has been registered on the service that they have offered. So, because of the trademark has been used by the others that has been providing the same service as the Econolas giving, so Cosgrove attempt to take action throughout this action that has been occur because of the copyright, the plagiarism toward the trademark that has been given out by Cosgrove and his partnerships. Thank you.
Okay, so for the conclusion in this chapter, element of licensing program, we can conclude that licensing agreement is a legal contract between two parties, which is licensor and licensee. Basically, the licensor grants the licensee the right to produce and sell products, or apply a brand name or trademark, or use a patented technology that owned by the licensor. So in exchange, the licensee submits to a series of conditions regarding the use of the licensor trademark or property and agrees to make the royalties. Moreover, there is an individual or company who got a great idea for a sport product or service but does not have the means or the will to sell it. So they still have the option to licensing their product or service or idea to another company. In another word, they can sign their idea over to another company and let them do all the work. Adversely, they will have less control over the product or service. So before making decision, think it wisely. Thank you. That's all from us.